Hello, Mr. Petrillos.
Calling this meeting to order at 3:34.
This is the meeting of the Sunshine Ordinance Task Force Education Outreach and Training Committee, meeting of August 15th, 2017. On the call of the roll, Member Eldon. Eldon present. Member Fisher.
Present.
Fisher present. Chair Josh Wolf.
Present.
Josh Wolf present. We have a quorum. There are no agenda changes that I know of at this time. Next on the agenda is item number 2, adoption of the minutes from the June 20th, 2017 Education Outreach and Training Committee meeting.
Is there a motion to approve the minutes?
Motion to approve?
Second. All right. By acclamation? Oh, public comment, sorry. Seeing none, by acclamation?
Sure.
The motion passes without objection. Next on the agenda is item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Ready? Hi, Michael Petrillos. I would like to use public comment to call attention to the 4 or 6 cameras that are now installed in this room. I am asking folks to investigate if they are operational and if the task force will be able to broadcast at least the full monthly meetings on SF.gov TV. I think it is a great step forward for open government that this room is now camera ready, because there are other agencies such as the Housing Authority that meet in this room that would like to air their meetings on TV, but because the room hasn't been wired up until now, folks were not allowed to do that. So that's my public comment. Thank you.
Great, thank you. Just so you're informed, another committee has been looking into the matter. There's a significant expense to hire someone to switch the cameras. We don't have a source for that money at this moment, and we are now looking into whether it'd be possible to utilize just a fixed camera. So we're on it.
Yes.
All right. Anyone else speaking for public comment today? Great. Thank you.
Next on the agenda, item number 4, file number 17083, complaint filed by Mike Petrillos is against the Police Commission for allegedly violating Administrative Code Section 67.25 by failing to respond to an immediate disclosure request in a timely and or complete manner.
All right, Mr. Petrillos, you.
So you have jurisdiction,
I
correct?
haven't made that determination yet, but they can review your testimony and make that determination at a later time.
Gotcha. Okay. Hi, Michael
Like
Petrillos.
3 or 5 minutes at this time.
Let's go with 3 minutes because we can always ask questions to clear anything up. So you have 3 minutes, Mr. Petrillos.
Thank you. Hi, Michael Petrillos again. If you look on page 15 of this packet, the agenda packet, on P15, there is the section of the Sunshine Statute, section 67.8-1, regards closed sessions. So I started looking at these 2 paragraphs, and based on what I read, I filed a request with the Police Commission for I believe it was written minutes. I'm not sure if I asked for video. What did I ask for? Public records. Well, in any event, I wanted to know what records I could obtain from, I believe it was a 6-month period of minutes from closed-door sessions that the Police Commission had held, because I believe it is clearly spelled out here that if 2 years after the meeting takes place where the Commission went into closed session and no litigation is filed, it says, upon expiration of the statute of limitations of the anticipated litigation, if no litigation is filed, as soon as the controversy leading to the anticipated anticipated litigation is concluded, the police commission has a duty to then release the minutes of what happened in that closed session. Okay, so that's the basis of this complaint. And I asked a number of police watchdogs and open government watchdogs if they knew of an instance where the Sunshine Ordinance Task Force had delved into these two paragraphs and the public requesting minutes or video or audio recordings from the closed sessions that met the requirement. Basically, it says to me that 2 years prior, let's say it's 3 years ago, the police commission met in closed session about cases 1 and 2, and I'm saying, though, if those cases did not go to litigation and they're basically been solved, 3 years later, I'm entitled to the public records that were kept on what they discussed in closed session. I hope I've explained that well.
Great. Thank you. I guess we should hear from the other side, and then we'll come back for questions. Well, we actually don't.
Hi. Good afternoon. My name is Sergeant Angela Rodriguez. I am assigned to the Police Commission office. On June 19, 2017, the Police Commission received the immediate disclosure request for copies or access to audio or video recordings of all Commission closed-door sessions from January 1st through May 31st, 2015. I responded on June 20th that per Administrative Code 67.25a, this was not a simple or routine request, therefore it did not fall under the parameters of an immediate disclosure request, and the normal timelines would apply to the request. On 6/23, Mr. Petrellis inquired if I was still working on his request, and I responded that I was. On 6/28, 2017, pursuant to Government Code Section 6253C, I sent a letter to Mr. Petrellis regarding the request for an extension with notice that we would respond no later than July 11, 2017. On July 5th, 2017, after getting direction from the city attorney, I sent a final response letter to Mr. Petrellis. All of the items in the closed session of the Police Commission meetings between January 1st and May 31st, 2015 included discipline, personnel issues, and existing litigation. In summary, the letter explained to Mr. Petrellis the following. We declined to disclose audio recording and documents associated with the closed sessions involving personnel matters. Regarding the closed session evaluation of the chief, this matter included evaluation of his performance, which is considered a personnel matter. Therefore, no recording or documents were disclosed. Regarding the closed sessions for peace officer disciplinary proceedings, the disciplinary proceedings are confidential under Penal Code Section 832.7. The California Supreme Court has held that Section 832.7 mandates the confidentiality of all records of peace officer disciplinary proceedings. And although the Sunshine Ordinance requires the Commission to release closed session recordings whenever all rationales for closing the session are no longer applicable, the peace officer disciplinary proceedings must remain confidential based on California Penal Code Section 832.7 and find that the rationale for these closed sessions remain applicable. As well, the Commission met regarding pending litigation for 2 cases. These closed sessions discussions were for the purpose of discussing existing litigation with counsel, and it is subject to the attorney-client privilege and is exempt from disclosure under the California Public Records Act. Lastly, confidential information acquired in any closed session may not be disclosed
Go ahead and finish.
unless the body that held the closed session, in this case the Police Commission, votes to disclose the information. In all the instances, the Police Commission voted to not disclose the information discussed in closed session.
Great, thank you. All right, Mr. Petrellis, can you Quick question. So it sounds to me like there's sort of three areas, three dominions that there were closed session hearings. And I heard an argument for one of those three. Do you have an argument for the other two dominions that do not pertain to potential litigation?
Yes.
Can you go ahead and briefly explain why you feel that either or both of those categories should be turned over?
First of all, I don't accept at face value what public servants tell me, and I especially don't accept it when it's coming from the police about reasons why public records have to be confidential. I secondly think that there may be just a blanket policy, a blanket rejection of such requests invoking the police officer's right to confidentiality. I am hoping that the Sunshine Ordinance Task Force is going to delve into this very deeply to address the issue of public trust in what the cops are saying about why these other categories apply that prevent them from releasing a record of what was discussed in closed session. I think this also gets to the matter of while the commission voted 2 years ago not to disclose what was said in the closed session, I would like for them to vote now, 2.5 years later, on whether they will disclose the records of the cases that did not go to litigation.
And I'm not entirely sure that the task force is necessarily the right venue to put that request to the police commission. Have you asked the police commission to put that on their agenda at this point in time?
I don't believe I have. I think we've been in communication about what may be available from previous periods, right? Right. Okay. So, no, I have not requested that they put this on the agenda.
So given that this is sort of a preliminary process, I think it might be wise to start the ball in motion to see if the police commission will vote to do exactly as you said. And when this is scheduled, I'm not suggesting we delay this process in any way, but by the time it comes up, perhaps there'll be some progress in that, and we'll be able to know where that's progressing as well. Does that make sense to you?
Makes sense. I think it's a terrific idea. And my first question to the police will be, how does a member of the public request an item be placed on their agenda? I've never done that, and I'm curious to learn.
Great. Any other questions for Mr. Petrolis? All right. Thank you, Mr. Petrolis. And any other questions for any questions for the police? All right. Is there anyone here speaking in behalf of the complainant or the defendant? Great. All right. So what are people's thoughts?
I don't see any violation.
I mean,
It says very quietly.
this process is still sort of evolving, but it seems like our chair is not really looking for us to identify whether or not there is a violation, but sort of make sense of the situation. And it seems to me that there's sort of, as I said earlier, three categories. There's the search for the chief of police that pertains to closed session. I think there's some other personnel matter, if I heard correctly. 3 disciplinary proceedings, and then there's the pending litigation. I think Mr. Petrolis' argument around expired litigation opens some interesting doors that I would like to see pursued in the hearing itself. I'm not seeing an overwhelming source of evidence that the other 2 categories seem to have much argument to be made public. Any other thoughts on this disagreement with where I'm at on this? All right. And then at this time, are we able to identify that we have jurisdiction in this case and that the record being sought is a public record?
Wait a minute. I'll go with jurisdiction. Do we need a motion for that right now? Did we do that yet?
We have
we
not
can
made
do
any
that now.
motions.
Okay.
We can combine the motion, or we can take them separately.
Separately, please. I'd like to
Okay,
make a
would you like-
motion. I'd like to make a motion that the task force has jurisdiction, as it is the police department.
And to determine that the records are,
Oh, can we finish that one?
Well, so we haven't had a second on any motion yet. Victor, can you briefly explain what it means to determine that the records are public records? Because my understanding is that doesn't mean that we're concluding that there isn't unpublic information, just that it is a public record under the pretense that all government records are public records that may have not public information.
Or is it like a potential public record? I don't know what else.
Victor, if you can enlighten us.
That's what I'm hung up on here.
we are determining that the record in question is a public record in the possession of a city department. However, we are not determining whether or not that public record is disclosable or not at this time.
All right, I'll live with that then.
Great. So do you want to go ahead and make that motion then?
Sure. I'll make the motion that the task force has jurisdiction and that the record is a public record to be determined whether it can be disclosed. Or is that too much?
Great.
That's fine.
Is there a second? Wonderful. Is there any public comment on that motion?
I've done that, so.
Well, seeing none, if you can go ahead and call the roll.
On the motion, Member Eldon. Aye. Eldon, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
All right, next item, please.
We need to refer it out, or
Doesn't it just naturally go to the full task
we
force?
still need to make a motion to refer it out. It's you made a determination. We do
Oh, we
need,
still. Oh, I'm sorry. I should have added. Someone should have added that to the motion. But does someone want to come a motion to refer to the full task force?
I will make a motion that we refer this item number, blah, 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 to the full task force. What item number is it? Sorry. 17083.
Is there a second?
Just to be clear, the process that the task force chair Wolf wants now is we are not recommending a violation, or we are. I mean,
My
I think we're
understanding.
recommending. We would be ready to recommend no violation. for this.
it's at the discretion of the committee how they want to proceed. However, it is my understanding that we're referring it to the task force for hearing, and you can present your opinions or findings at the full task force meeting.
I mean, given that there's, like we discussed, the complainant needs to follow through with.
You can provide what you believe your findings are at this time, sort of like I will write it into the minutes, but it will become part of the recommendation in it, as it is part of the minutes, that this is, I'm not making the decision for you at this time, but in regards to personnel records of police officers, that is my understanding that you believe those might still be confidential documents or closed records. However, you are looking for more information regarding pending litigation that has expired, and maybe that you've asked that the complainant touch base with the police department regarding, I didn't quite get that part of it.
As I understand it, and Mr. Petrolis, please correct me if I'm wrong, towards the end of Mr. Petrolis' opening statement, he concluded that he would like to ask the police commission to vote to make these records, remove them from closed session to make them public. And I'm not sure whether it's advisable for this committee to make a formal recommendation to do so or not. It was more speaking over the dais or whatever to as one.
The discussion occurred, and I
Right.
won't go any further than that.
I'm fine with it in the minutes. I'm just sort of not sure where it best belongs.
Yes.
So
I have
right
the
now we
motion
have
by
a
Member Fisher. I do not have a second yet.
And so Fisher's motion has no recommendation, positive or negative, as I understand
That is
it.
correct.
But I'm allowed to do one?
It'll be up to the other members to vote on.
We
it.
should let this motion die if you
Okay,
want
do
to
I have
change
I'd like
your
to withdraw
motion.
your motion.
Sure, I'll withdraw the motion.
Would you like to make a new motion at this time?
Are we in agreement?
I mean, I'm in agreement that there hasn't been any evidence shown for the disciplinary and the police chief categories, but there seems to be something worth looking into on the expired
You
legislation.
can make that motion too if you want. I'll second
I would prefer to make a motion with no recommendation personally, but
That would probably be best, that way we do not have to divide the categories with different motions.
it. Okay. So I could have left the one I had.
Yes, I believe the motion made by...
Can I withdraw the withdrawal?
The motion on the floor by Member Fisher is to refer the matter to the full task force for hearing at this time.
I'll second that.
Okay.
Any
Sure.
public comment on that motion? Seeing none, if you could call the roll.
On that motion, Member Eldon.
Aye.
Eldon, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes. This matter will be scheduled before the full task force. I do not anticipate, I should say I anticipate either the first Wednesday in October is my best estimate at this time. And as this is a police commission item, it will be the first matter on the agenda as they have a meeting next door at 5 o'clock.
Great. Thank you. All right, if you could call the next item and also a little bit of background about how it got referred from the complaint committee to us.
Yes, next on the agenda, item number 5, file number 17077, complaint filed by Andrew Bowe against Dwight Moore, Office of the City Attorney for allegedly violating Administrative Code, Section 67.25, by failing to respond to an immediate disclosure request in a timely and or complete manner. And in regards to the complaint committee, the only function that they performed was to determine that the task force has jurisdiction in order to meet the 45-day rule. They had no hearings on the merits of the matter. And,
Did they run out of time, or what was the reason that it was scheduled?
Only for the purpose of determining whether or not we had jurisdiction.
Due to a capacity issue? I'm just trying to understand.
It was due to a capacity issue.
Okay, great.
It was scheduled just to look at the jurisdiction issue only, and then I allocated to the other committees, time permitting.
Sure. All right, go ahead.
Hi. I did file a response, but I don't see it in the packet. It would have had the timeline and a narrative about it. So basically, this is a late response, 6725. I sent the IDR. I waited 10 days, and I filed a complaint because there was no response. I didn't get an auto away message from this person. And the reason why I sent it directly to the investigator is he's the person who would have most direct knowledge of this case because he worked on it. So the violation is 6725. At the jurisdiction hearing, Chair testified, said that investigative notes were disclosable, and that's what I was looking for. This was a case that I won in the State Court of Appeal, First District. Here, as you see, is the declaration of Dwight Moore and a certified copy from the underlying court, where there was no Exhibit A, which he claimed under oath was there. A CD-ROM is not admissible under California rules of court. So this Exhibit A...
Can you pull the microphone, please?
Yeah. This Exhibit A was a Xerox copy of a CD-ROM. It was not evidence. This CD-ROM never surfaced. It was just not there. So there was no evidence to this case. And he lied in his affidavit to the court, which is here, certified copy. So still to this day, I'm asking, well, where's the evidence for this case? Because I spent a year, doing filings and stuff of something that I was innocent of, and I still would like to see the evidence. So this claim that it's attorney-client privilege and attorney-client work product is wrong, because the city attorney's office is not law enforcement. They're not subject to the ongoing investigation or the things, the high standard that would be required. So being that Chair testified said, and I believe these investigative notes are public information, I should be entitled to get them. The claim that Dwight Moore didn't know who I was is kind of laughable to me, since he sent me 41 text messages at that time, and he was also harassing my family in New York. I don't know why. They actually got filed police reports on him. So, inadvertent delay, understandable, dismissal, absolutely not. This is the second time John Cote has come in when I've asked for documents. It's been a late response, and I'd like to see a violation here.
Right, thanks. Before you return to your seat, you made one statement that I just want some clarity on. So I understand that a photograph of a CD-ROM is not evidence of the data on the CD. But I think you said that a CD-ROM itself is not admissible in California court. I don't know whether that's true or not.
It is true.
Okay, so I want to record that in the minutes to have us look into whether or not that is true, because I have no idea and I'm not in a position. That's fine. I just wanted to make sure that's what I heard correctly.
At the full hearing, I'll be happy to bring in the opinion from Justice Berniers, which states very clearly that a CD-ROM is inadmissible.
I'm not doubting your legal expertise, but we have a lawyer to confirm how the law actually is written. So,
okay.
Great. Thank you.
You're welcome.
All right. Will the respondent, please?
Good afternoon, task force members. John Cote. I'm the communications director with
Pull the mic up.
Oh, sorry.
Thank you.
No problem. I'm the communications director with the city attorney's office. So I'll be brief. I would refer you to the written response that I provided back on July 18th. I believe it's page 52 of your packet. So at the time, the immediate disclosure request was sent to Dwight Moore, an investigator in our office. He was out of the office at that point. When he returned to the office, he had been gone for approximately 2 weeks. I know Ms. Trudeau made the assertion that she did not receive an out-of-office reply. That's not, in fact, correct. He did have an out-of-office notification on his email, and it shows that a notification went to atribo10 at AOL.com. When Mr. Moore became aware that this was an issue, which was only after a complaint had been filed, he had viewed that, as I indicated in my written response, he was inundated. His inbox was full, and he was inundated with emails when he returned. When he realized that there was, in fact, a sunshine request in there, our office responded the next day. As far as the issue of, and in that response, which is included in your packet, we note that there are no responsive documents, and that the only the documents that could potentially be responsive were investigative notes that are, in fact, covered under both the attorney-client privilege and attorney work product privilege.
Great. Thank you.
Sure.
Ms. Trudeau? So I think I understand this, but let me try to summarize and see what I get wrong. It sounds like first you filed the IDR, which didn't get a response to respond to the IDR within 24 hours, whether that was within the next business day, whether that was to ask for a delay or anywise. It seems like the city attorney's representative has acknowledged that there wasn't a response at that point. And then in terms of if it had been a regular public records request, it still didn't meet that time window. So there's those two issues, and then additionally, you feel that the response that there's no responsive records is not accurate. Does that sum it up?
That sums it up very well. And my issue is with the third part of it. any court documents, unless they're sealed, are public information. So what they're giving me is what I already know. He's talking about an Exhibit A that doesn't exist, and he's talking about something else. Well, anybody could have gotten that by going to the court. I'm looking for specific information. So according to the Sunshine Ordinance, they, and I believe that they should have identified what documents they have. I already know there are no police reports because I've been to 850 Bryant Street. I know that there's no transcript because it would have been included in the court filing. I know that there may be phone tapes, but they haven't identified what they have and what they don't have. They just left this blanket thing. We're not going to turn over anything. So I did not receive any information from this document request, which was helpful to me. I spent a year doing research in the law library preparing for this case, and I wouldn't like this to happen to anybody else. This might be a little bit off topic, but there were other cases in this San Francisco Superior Court civil where the city attorney's office has done the same thing. This game of providing a Xerox copy of a CD-ROM, it may have escape Judge Crompton because it's the city attorney's office and two attorneys are coming into court. But that's the purpose of the appellate court, to review the documents that are presented in front of them. And this is one of the reasons why I won the case. And I would not like to see citizens have to go through what I went through simply because somebody's pissed off and somebody in the city attorney's office lied in court, lied in an affidavit, and is backed up by other people. This trick of the CD-ROM, as I've seen it in other cases, because I did a lot of research. Okay. And that's the reason why I filed this.
Any other questions for Ms. Trudeau? All right, seeing none from my colleagues. Mr. Cote? So I just want to talk briefly about the sort of process that happened when when Ms. Trudeau sent the email to the investigator.
Sure.
Our ad hoc technology committee has been looking into this because it happens throughout city departments that someone will send an email to someone that might not normally receive a lot of public records requests. And they tend to catch it if it's a normal public records request, but when it comes to these immediate disclosure requests, whether it's due to employees being away or just not used to receiving IDRs, that the timelines aren't being met. And the law doesn't seem to provide much in the way of exception to the fact that, emails don't always go through to people in a proper time. And it's kind of unclear in terms of the auto response. We have many people claiming they don't receive them, and it's unclear whether the auto response is necessarily an indication requesting more time or not. It's just a response saying they're not there. So to get to the real heart of the question, which is that in our conversations with the tech, I'm not sure what, some tech entity that oversees the city and deals with I think it's the Microsoft Exchange email system. Mm-hmm. We've learned that it is possible to have commands at a department level that say if the words immediate disclosure request, which is what's required under the law, is in an email, to automatically forward those to a party that could respond, within a timely manner. So my question is, have you looked into that? And if you have, why has or hasn't that been implemented?
So that particular technological solution is not one that I'm aware of. I understand your representation that other folks in the city are looking at that. Certainly it seems like it could be a effective remedy to the situation here where, if Ms. Trudeau's email had gone to, say, our main email line, which is monitored throughout the course of the business day, then it would have been responded to in a timely fashion. So if the technological capability exists to do that, as you're suggesting, I think that's certainly a workable solution. I would need to check with our technology folks to see where along in the process that is and if it can be implemented with our email system.
Great. And then, Victor, you were obviously there for our ad hoc tech meetings. What city agency was that we were having those conversations with?
I believe it was Department of Telecommunications.
Department of Telecommunications. Do you have the ability?
Sorry, not telecommunications. The Information Technology Department.
Information Technology Department. Mr. Cote, can you refer this question within your office, directing to the Information Technology Office to look into what's feasible before the next hearing?
I can ask. I mean, the other aspect is we also have our own in-house technology team, and so I don't know if, say, the solution that's being worked on at the Department of Information Technology is one that they're aware of, and if there are any sort of intricacies as far as implementing that solution, like in our office. I'm just
right. I mean, you deal with legal documents and confidential matter, and if there was someone suing over an IDR request, potentially the language could get moved over. I understand that there's some additional concerns than other city departments, but the request is like, can you do what you can to look into the matter? I've explained how Microsoft 365 would provide this way to do it.
Right.
So if you can sort of look into what's possible so that at the next hearing we can have an update on what might happen in the future.
Yeah, I'm happy to look into it. The one caveat you should be aware of is that our email system that we use in the office is not Microsoft Office 365.
You're the one department who don't use it.
I see.
Yeah.
That's what is your
that's
email?
the source of my hesitation is I need to double check to make sure that's compatible with
Sure
the
thing.
email
What is the
system
email provider that you guys use?
We use Lotus Notes.
I was just going to say, what, something like Lotus Notes or?
Yeah,
We're in the. My understanding is that we're in the process of transitioning to Outlook, but we currently use Lotus Notes, and so I don't want to say that we can, pursue a solution if it's not technically feasible with what we're using right now.
Right. So I guess the question is both like, what's possible today with Lotus Notes, and when you transition, is there any reason you wouldn't be able to implement this, whether it's technological or otherwise, in the future, just so that we have a sense of where the department will head moving forward?
So I'm certainly happy to look into the answers to those two questions.
That's great. Thanks so much. Any other questions for the city attorney's rep? Seeing no questions, I think that's it for you.
All right. Thanks.
All right. Thank you. Any questions for anyone at this point, or should we go ahead and move forward with a motion?
Chair Wolf?
Yes.
I believe it just might be my misunderstanding or clarification, but I wanted to ask Member Fisher's common question is, I'm not sure if there's a specific document that's missing that Ms. Trabeau is still looking for. It seemed, I didn't hear something specific, it's just very general.
Sure. Ms. Trabeau, you want to explain what specific documents, if any, you're looking for?
And investigative notes. I believe they are public documents. I believe they're disclosable. It was echoed by Chair Testify at the jurisdictional hearing. And my IDR was very specific. And we all know what it's like when you just get slammed saying documents are not disclosable under attorney-client privilege. You're left hanging. You don't know what documents they have. Maybe there are some that could be redacted or so. I asked for interdepartment emails, police reports. I believe that they may exist. Police reports don't exist, but specifically what I'm looking for are investigative notes. Because here in his affidavit, he makes the claim that what is supposed to be on the CD-ROM are phone calls that I made to Barbara Scalar, when in fact I sought, when I did the public record search and I saw there was a filing against me, I actually sought out, I was on the East Coast, I sought out the chief investigator guy, and he just maybe looked on some paperwork and he said, "Oh, you need to be back." That's all he said. So it's now 2 years later, and I'd still like to know where are these investigative notes? Because it was me who was reaching out to him.
So-
and
so-
I would like to see exactly what he's got.
So let's ask Mr. Code real fast about that, and then we'll dive into it with the hearing itself. But Mr. Code, are there any investigatory notes that pertain to this inquiry, and what is their status in terms of disclosability?
Sure. So as I noted in my response, I'd point you guys to fourth paragraph on page 52. We indicate that there, in the response, which I know that there's been some sort of discussion about Exhibit A and whatnot, and there's an Exhibit A that I referenced there, which has nothing to do with this document that is up.
Mr. Rowe, please.
It has nothing to do with the document that's up on the projection. I'm talking about Exhibit A to the documents that I provided to the task force, which is our response to Ms. Trabeau. So Exhibit A is our response to Ms. Trabeau on July 13th, in which we indicate that there are no responsive documents except for investigative notes. So there's no other types of documents that fall under this request that was submitted, except for investigative notes, which were made by Mr. Moore, and those are exempt from disclosure. They've been reviewed by the attorneys in our office, and in their professional view, attorney-client privilege and attorney work product privileges apply, and they're not disclosable.
All right. Thank you. And anyone ready to make a motion?
I guess my hang up with what the respondent said just now is that if in a case the city attorney's office was saying, well, this is the evidence, is that she was making these calls that we had recorded on the CD-ROM to Rachel Sklar, and then referencing them as evidence, but then they're not available to anyone to review because it's attorney-client privilege, then why should it be counted as evidence? That's the part that I'm unclear about, if you'd like to come back up.
So this CD-ROM that was part of an exhibit in court, do you mind if I take a look at that document? So it looks like it's dated May 3rd of 2015 and was submitted as part of a declaration. So
if the question I have is, if that's appearing in a court document as evidence, and it's referred to in the case as evidence, but it's not available to public records.
Well, no. If it's evidence that's submitted at court, it would be available like in the court file.
So
what's unclear to me is if we have this record in our office currently.
Well, if the complainant seeks to have the contents of that CD-ROM, you would provide them to her under.
I'd have to confer with the attorneys in our office, but my understanding is if it was a public record and had been submitted in court and was not under seal or for some other reason determined not to be disclosable by the court, if it was a public record, then obviously we would provide it.
Okay.
Anyone want to make a motion? From the way I look at it, it seems that there's definitely just a superficial timeliness violation. Whether these records are disclosable or not, I think remains to be seen. But I do see it hard to argue against just a basic timeliness violation. I did see that we definitely should have jurisdiction, and the document is a public document that may or may not be disclosable. So I say we move with a motion for.
We only need a motion to refer to the task force, as determination of jurisdiction has already been found.
Oh, okay. So do we want to make a motion identifying the timeliness violation, or just make a motion with no recommendation because we aren't sure how we feel about the other matters?
mean, the meat of the case is whether or not she can access the information she was seeking. And until we know that, I mean, until we get, I mean, that I think will be what gets fully explored at the full task force. So I'm fine going no recommendation because that, I mean, it's all going to come up anyway. And the heart of the matter will be reviewed in a way we can't right now.
And that'll help it not look like the heart of the matter is the timeliness issue when reviewed. So are you ready to make that motion?
Make a motion for no recommendation referral.
It's just a referral to the full task force for hearing.
Right.
Is there a second?
I'll second that.
Any public comment?
Could I add one additional?
Sure, go ahead.
Is that the discretion of the chair?
Just upon further review of the request that Ms. Trudeau submitted, as well as this document here, which is the first time I'm seeing this. I didn't see this in the packet or presented in her complaint. She notes in her request, she's requesting transcripts of all phone conversations between Trudeau and the investigator made in 2016. So this document and this item indicates, and I can put it up on the display, it says May 3rd, 2015. It says May 3rd, 2015, messages from Paula Detesh, which is one of her aliases. And so,
It's not an alias.
Ms. Trudeau, we'll give you a chance. Let's let Mr.
So what she's asking for in the request, even if our office had this item, and I don't know that we do, she's not asking for that item in her request. Her request is saying transcripts of all phone conversations between Trudeau and the investigator, in this case, Dwight Moore, made in 2016. And that's an item from May of 2015. So I just wanted to point that out to the task force.
Thank you. And Ms. Trudeau, you can respond, but only to the concerning Mr. Cote's claim that this CD itself is out of the scope of your request.
Okay. Firstly, there is no CD in any court file to be found. This is a previous filing, which is another trick of the city attorney's office. They used a CD-ROM of a previous case, made a copy of it, and tried to submit it as evidence. What I'm asking for wouldn't even be contained on a CD-ROM. They would be investigative notes.
Okay.
I would assume
Great.
when you're talking to somebody on the phone, they're making notes.
Great. Thank you. We're just moving the case with no recommendation, so it's going to be heard through the full task force at that level.
And I have no aliases. That is my name.
Great. Thank you. All right. So we have a second on that motion, right?
Yes, we do.
Great. Any public comment? Seeing no public, go ahead and call the roll.
Member Eldon.
Aye.
Eldon, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes. I would like to request that, Mr. Bowe, if you believe there are any items missing from my packet, if you can provide a copy to me so that I can include it into the next packet. Thank you.
Okay.
Next on the agenda.
Victor, before you actually move forward, I couldn't find the Exhibit A in the packet itself.
I do. What I have is what. That's why I just asked her if there's something I'm not.
Yes, but that Exhibit A actually came from the city attorney's office, so that same instruction should probably go out to both parties.
So if I may,
Of course.
through the chair, Exhibit A is page 54 of your packet.
Great. I just wasn't able to find it and want to make sure it's there when the full task force
Okay.
looks. So, thank you.
It's my
Sure.
assumption that there's not a page that says Exhibit A. Then.
All right, 54 is just response, right?
Yes. And so the Exhibit A that I'm referencing in my response to Mr. Young and the task force, I say, Again, on item 52 here in the fourth paragraph, I say response was sent before close of the next business day, July 13th, 2017. See attached Exhibit A. And you'll see on page 54, that is the attached response that I was designating as Exhibit A to our response.
Great. That's totally all we needed. It's not labeled Exhibit A for the way we look at it, so it was just
Got
a
it.
little confusing.
Okay.
All right. Thanks, everyone.
Cool.
When do you expect this would come up?
That's up to the
It
discretion.
will not
of the-
be, it will be at least the October or November meeting of the full task force. Notes will be provided.
Great. Thank you. And call the next item.
Next on the agenda, item number 6, announcements, comments, questions, future agenda items, and pending calendar by members of the Education Outreach and Training Committee.
I don't have any announcements myself. Anyone? Seeing no announcements, comments, questions.
Next on the agenda is adjournment.
And is there a motion to adjourn?
But I'm sorry, wasn't there public comment?
We've already had public comment at the beginning of the meeting. I'm sorry.
But that was an agenda item.
No,
Yes,
it
it-
is on comments by the members of the task force, and they had no comments, so there's nothing to comment on.
All right. Adjournment.
I'll make a motion to adjourn.
All right.
Second?
Any public comment on adjournment? Seeing none. Adjourned. Adjourned.